You rented your property to Claire, and you did so on the basis of an assured short-hold tenancy. That gives you legal obligations to Claire, rights and responsibilities she has, and rights and responsibilities you have as a landlord, clearly set out in what I consider to be a perfect contract. You were of the view that she had abandoned the property. As a result, you took that as notice of her having left. You've gone onto that property in circumstances where you needed to jump through the relevant legal hoops in order to take possession. Even though this was unlawful, Claire, your remedy in the circumstances would have been to go to court, and the court may have said to you, this was an unlawful eviction. You may go back into that property. So, what you've lost in respect of his unlawful eviction is only the fact that you can't go back there. You didn't want to go back there in any event. I now turn to you, Trev. You have three parts of your claim. The first amount is for £1,200 in unpaid rent. Because you took repossession of the property, it would be unreasonable to enforce the terms of the contract. The eviction was for November. Your claim is for November, December and January. You are not entitled to that money. You decided, without taking an itinerary, but taking good evidence, to get a skip and to remove everything in that property and to employ your friend. The total that you spent with a skip and employing that gentleman over there was £1,048. Now, I'll be absolutely clear. Had this been a state of straightforward abandonment, I would have no difficulty whatsoever in giving you that money. I am perfectly satisfied that Claire caused the house to be in that state. You had to clean it up, and it cost you £1,048. Without giving her an opportunity to go through and obtain, for example, some things which may not have inherent value but have value to her, I have to come up with a view as to what her damages are. In this matter, she is proceeding against you for £5,000. That is palpably absurd. On any view, looking at the value of the things that I have seen, £5,000 is ridiculous. Nothing in that house was worth that value. However, I am confident that there were things in there that could have been salvaged, that she may have thought were valuable. Beds, perhaps a television. But above all else, items that were invaluable to her. They have a cost. That cost is left to judges to come up to a determination about, because really they only have emotional value. I take the view that, frankly, on the face of it, she would be, in any other court, entitled to claim the value of £1,000. I accept that you had no other choice but to get rid of this stuff, and you would ordinarily be entitled to the £1,048. However, because of the nature of how you obtained this property and the fact that you destroyed it without giving Claire an opportunity to salvage some of it, £1,000 has to be deducted from that value. This court therefore awards you £48. That's the award of this court.
Trevor was awarded just £48 of his claim, after the value of Claire's counterclaim was deducted from his award.